DUI and refusing a Sobriety BAC test under the Implied Consent Law, Part 1. A police officer may pull over a driver and request that they submit to a blood alcohol concentration (BAC) test if they have reason to believe that the driver is intoxicated. Typically, this entails passing a roadside breathalyzer test. An arrest for driving under the influence will occur for any breathalyzer readings that are above 0.08%. Likewise, if a person's behavior indicates that their ability to drive is compromised while having a permissible BAC, they may still be detained. Keep in mind that some people can become impaired even with very low BACs of 0.02% or 0.03%. If an officer pulls you over on suspicion of DUI, as a driver you must be aware of your rights and responsibilities under the law. Although you are legally compelled to submit to a BAC test, no one can physically force you to do so. The consequences of refusing to take a breathalyzer test are typically severe. Due to the implied consent statute, if a police officer has cause to believe you are driving while intoxicated, you have already made a legally enforceable commitment to submit to a BAC test when requested to do so. Implied consent laws exist in some form in each of the 50 states. If a police officer suspects you of operating a vehicle while inebriated, you have automatically consented to a chemical test by getting a driver's license and using public transportation. This is known as implied consent. You legally promised to permit a BAC test during a roadside DUI stop when you signed your driver's license application documents. That promise's breach will result in severe, unfavorable consequences. Refusing a chemical test could result in a substantial fine and an immediate driving ban depending on the rules in your state. Several kinds of chemical tests, blood, urine, or breath tests can be used to measure blood alcohol content. Given that a breath test is the quickest and least invasive way to determine BAC, the majority of states have laws requiring drivers who are pulled over on suspicion of DUI to submit to one. To learn more about your state's regulations, consult the driving manual. Some jurisdictions, however, allow drivers to request a blood or urine test instead. You can be obliged to cover the cost of the test's medical care if you are given the choice between taking a breath test and having a blood or urine test requested. The most accurate way to determine a person's BAC is through blood tests. You must submit to a blood test if law enforcement demands so under the implied consent statute. According to data gathered by the NHTSA, DUI offenders who refuse a blood test typically face larger fines and lengthier imprisonment. This is believed to be the case since refusing the test shows a lack of collaboration and a desire to cover up guilt. Roadside sobriety checks. In some states, field sobriety tests are not subject to the implied consent statute. Officers can employ field sobriety tests, FSDs, as investigative techniques to determine whether a subject may be under the influence of alcohol. They can be recorded and used as proof in DUI trials, but they cannot be definitively failed or passed. Although there are several types of field sobriety tests used around the country, law enforcement officials often rely on 3 standard tests because they are approved by the NHTSA, which are horizontal gaze nystagmus, first, HGN. When shifting their attention significantly to the left or right along a horizontal plane, people with high blood alcohol concentrations frequently experience nystagmus, an uncontrollable, jerking eye movement. A police officer will ask the suspect to follow an object with their eyes as they move it side to side while doing a horizontal gaze nystagmus test. Nystagmus that starts at or before a 45-degree angle is typically indicative of intoxication in the test subject. According to the NHTSA, this test has a 77% accuracy rate for assessing whether a person's blood alcohol concentration is above the legal limit. Two-legged stand, OLS. Balance impairment is a common side effect of alcohol consumption. The one-leg stand test may be used by a law enforcement officer to determine whether someone is impaired. The suspect will be instructed to stand with their legs together, elevate one foot approximately 6 inches off the ground, and balance there for 30 seconds. The suspect may be inebriated if they are swaying, hopping, using their arms for balance, wobbling, or putting their foot down. 3. Turn and walk, WAT. The walk and turn test is intended to reveal coordination issues and trouble following directions that may be brought on by alcohol intoxication. The suspect will be required to take 9 steps in a straight line with each heel coming into contact with the toes of the back foot as part of the test. Then they will be told to pivot and repeat the exercise while moving in the reverse direction. The suspect may be intoxicated if they take the incorrect amount of steps, lose their balance, walk off the path, stop, or leave a space between their feet. According to the NHTSA, this sobriety test successfully detects intoxication in about 68% of instances. While you are required by law to submit to a breath test to determine your blood alcohol content, BAC, you may have the right to decline a sobriety test. Be sure to check this out in your state's driving manual. Many people argue that taking poorly on a field sobriety test would be used against them in court if a video of the exam were to be revealed. Remember that even if a breathalyzer test shows that you are below the legal limit of 0.08%, an officer can nevertheless detain you on suspicion of DUI. Despite this worry, it is still best to cooperate as completely as you can with law authorities when you are pulled over on the side of the road on suspicion of DUI or another crime. It is quite possible that you will be arrested if you refuse to take a field sobriety test if the police officer believes your driving suggests intoxication. DUI and refusing a sobriety BAC test under the Implied Consent Law, Part 2. Declining a BAC test. Even if you are not ultimately charged with or found guilty of DUI, you will still face consequences if you refuse to undergo a breath, blood, or urine test because of the implied consent rule. State-by-state variations exist in these sanctions. The number of drivers who refuse BAC tests in a state each year is a good indicator of how severe that state's implied consent sanctions are. Around 20% of all drivers nationwide who are pulled over on suspicion of DUI refuse to take a blood alcohol test, according to the NHTSA. According to state statistics, refusal rates range from 2.4% in Delaware, where there are significant sanctions, to 81% in New Hampshire, where penalties are relatively mild. Whatever the penalties are in your state for refusing a BAC test, be aware that doing so won't likely prevent you from getting a DUI conviction. Refusing a test is taken as evidence of guilt because it is presumed that an innocent individual would consent to a test because they have nothing to conceal. Enforce refusal to accept. In an effort to escape a DUI conviction, a driver who is aware that they would fail a BAC test may decide to accept the consequences of doing so. Many states have implemented no refusal enforcement rules to address this issue. Where these regulations are in effect, police officers may ask a judge for a warrant allowing them to administer a BAC test without the suspect's permission. In the foolish belief that their blood alcohol level will have decreased by the time an officer can obtain a warrant, drunk drivers frequently resist breathalyzer tests. Today, the majority of law enforcement personnel can quickly get electronic warrants using their mobile devices. Even after a warrant has been acquired, someone who refuses to take a breathalyzer test will probably be charged with contempt. In the end, they will still be detained and have blood drawn for a BAC test. It will be taken by force if necessary. Refusal of a BAC test penalties. Refusing a breath test in violation of implied consent may result in fines, automatic license suspension, or complete license revocation. If the person who refused the test is subsequently found guilty of DUI, their failure to cooperate will probably result in higher penalties. If you refuse a breath test, the following things could happen in various states. Florida, a license suspension that is automatic and lasts up to a year. Texas, up to 180 days automatic license suspension. In New York, there is a $500 maximum fine and an automatic license suspension of up to 6 months. Massachusetts, a permanent license revocation if you are found guilty of DUI and an immediate license suspension of up to 6 months. Currently, when a driver declines to submit to a breath test, 42 states automatically suspend or revoke their driver's license. This means that by refusing the test, the police officer who pulled you over is free to immediately confiscate your driver's license. Obeying laws requiring implied consent. Driving is not a right but a luxury. You should consider signing your driver's license forms as getting into a contract with the DMV and local law enforcement. You made a commitment to follow the law, drive defensively to protect other drivers and property, and assist anti-DUI enforcement efforts in exchange for your driving privileges. Refusing to submit to a BAC test in violation of that agreement is a serious offense, and your driving privileges could be suspended as a result. If you are stopped on suspicion of DUI, refusing a test may seem like a wise decision, but it will always worsen the situation.